Good morning, everyone. We are at 10 o'clock, ready to start our meeting. Um, Before we get started today, I just want to go over our Zoom housekeeping and instructions. We are here to give general legal information, not legal advice. Please keep that in mind when it comes to your questions and as to the chat function as well. The chat function is intended for questions or requests for clarification and commentary. The chat is not to be interpreted as any type of legal advice. Uh, Also keep in mind, we reserve the right to reject questions for any reason, including if the question comes from an unidentified source. We wanted to let you know that with the upcoming holidays, we will not be holding the Zoom Q&A on December 24th, Christmas Eve, or December 31st, New Year's Eve. We will resume in January 2026. Please keep in mind that changes to Wakaiowa took place on July 27th. Several new provisions will become binding on all communities effective January 1st, 2026, relating specifically to meetings and collections notices. There are new limits on the amount of late fees and administrative fees until after pre-foreclosure notices have been mailed to any owner. So if you have any questions about those, we have had several Q&A sessions relating to these, and contact your association attorney if you have specific questions about that. And let's see, I think, Katie, we are ready for the first question.
Sure. And we probably will have time to answer questions. So if you didn't get your question in before 4 on Monday, then we might have time to get to it at the end. So feel free to put it in the chat. Also, just remember that if you have questions that we may not get to today, questions must be submitted by 4 p.m. on Monday, and we've put our standard little blurb in the chat. Some of you who joined more recently may not see it, so I will just resend it now. It also has the link for our YouTube channel in case you want to go back and review anything. So our first question today is about providing owner email addresses when requested by an owner. So the question is, managers maintain email lists of all owners and residents. Must that list be provided to any owner that asks? So the background on this is the statute regarding list of owners was modified in 2024 to discuss electronic email addresses. It now specifically includes email, or it says electronic communication. So in theory, it could include like a cell phone number if an owner opts in to receive notice by text. But we're just going to say email for purposes of this because it is what most people use. So this is also when the 10-day requirement to respond to a records request and the 20-day time limit was imposed on how quickly documents must be provided. So this is for Ukiah communities only currently. I don't think it went into the other statutes. So for the most part, those still have the same records provisions in that you just have to provide them within a reasonable amount of time. Ukiah is what says you have to provide them within 10 days or 21 days if things have to be redacted. And then you could get more time if you go and you ask a court. So again, the question is, what emails can the association withhold to prevent owners emailing everyone and to protect owners' privacy? The statute, again, this is just Ukiah, is pretty clear that if an owner states to the association they want their email kept confidential, that would not be disclosed. So whether it is the email address that they have opted in to receive official notice from, or it's just an email that they don't receive official notice from, but they'll email their complaints or whatever. If they've said they want that email kept confidential, it's not disclosed regardless. So where we run into the question is, what about either the email that the owner communicates with that's not their official opt-in email, or what about if they've opted in to receive notice by email and they haven't said they want it kept confidential. So for the latter one, if they have opted in to receive notice by email and they have not said they want it kept confidential, then it should be disclosed under the statute. The statute requires that the address, whether it be physical or electronic, be provided to the owner who's requesting it, unless the owner has requested it be kept confidential. So if an owner has agreed to electronic notice and has not requested that their email be kept confidential, then the association must disclose that email because that is the method by which the association formally communicates with the owner. However, what if it's just what they email their complaints from and they haven't requested it to be confidential? Our position is if an owner has like I said, asked if it be confidential, keep confidential. If an owner has not agreed to electronic notice and they haven't asked if it's confidential, then that email should not be disclosed because it's not the method by which the association formally communicates with the owner. Only regular mail is. So our recommendation, if you get this request, or even with people opting in or not opting in to electronic notice, saying they want to keep it confidential or not, is send a request to all owners asking them to agree to notice from the association by email. First, that makes it a lot cheaper because the email is a lot cheaper than mailing out a bunch of notices. It also is easier to communicate over email. It's faster. It doesn't change the notice requirements for timing, but more people check their email than they check their regular mail. With that request, because again, owners have to opt in, you can ask them to opt in, but with that request asking them to opt in to notice by email, you can ask them if the association should keep their email address confidential or if they can share it with owners who request email addresses. Because I will say, owners probably, some of them want notice by email, but they're not going to go look at the statute and know if they have to ask to keep it confidential or not. So the association can affirmatively go out and ask if they want it kept confidential, ask if they want to opt in. And if they, like I said, if they want to keep it confidential, even if it's the formal way of communicating with them, it does not need to be disclosed if an owner requests it. Tima, do you want to add anything on that?
No, I think that covers it pretty thoroughly. The second question is, what do we do? We've actually had this question come in twice recently, so this is something we've decided to address today because it seems to be coming up. So what do we do about an owner who repeatedly emails the manager or the board about the same topic and essentially disagreeing with board or manager actions? So I guess the short answer is obviously we can't make any specific recommendation here because we don't have all the facts or circumstances. Our general legal advice is I would start with basic advice, psychology 101 of community association law. Sometimes people want to be heard. And it's very important that at least this owner, no matter how many times they're repeating themselves, is acknowledged and that there's some response given showing that their complaint has been received and is under consideration and review. So ignoring them, as annoying that they may be, is not a good response. You always want to have some response. So that's the first thing. Secondly, when you do respond, you'll want to acknowledge that you are taking the matter seriously, it's under investigation, and again, that they're not being ignored. I would also recommend, we would recommend to confirm to confirm to a complaining owner that the board has been advised of the concerns and it will be considered at a board meeting. So not just that it's been heard, but that it'll be reviewed at a board meeting, and remind them that decisions can only be taken at board meetings. So just submitting the complaint doesn't necessarily mean that a decision can be made that way. The decision has to be made after board review. And individual board members specifically. So for example, if an owner is reporting this issue continuously to a single board member, that single board member needs to also remind that owner that individual board members have no specific power to make decisions. These decisions are made under the board as a whole. Let's see. We would also recommend that the complaint or demand be put on the agenda for the next board meeting, which is going to be shared with the ownership. And it doesn't mean that necessarily the board will be able to do anything about it, but if it's on the agenda and if it's under consideration and a motion is made not to take action, at least that owner has been acknowledged and acknowledged in their complaint in that board meeting. And again, it depends, again, we don't have any specifics here. I don't know what the complaint is about. If it's something, for example, relating to tree maintenance or lawn maintenance or something specific like that, you could put that on the agenda. The board can choose not to take action, or it can reconsider past actions, or it can take new actions. But putting the itemized complaint on the agenda will at least fulfill that consideration requirement. Why would you want to put it on the agenda? To be more specific, if you put it on the agenda, you're eliminating claims by owners that managers are making decisions and not the board. So if you have a managed association, that will take some of that criticism off of the manager and the board, that perception that managers are making decisions. It eliminates claims that one board member is making decisions as opposed to the board as a whole, which is the collective decision making is obviously what's required. It eliminates claims that the board did not fulfill its obligation to act in good faith and with reasonable care. Also, adding it to the agenda will provide a record in the meeting minutes that the board knew about the issue, took action, even if the action was to affirm a past decision, or to, reject new action, for example. Also, putting it on the agenda gives you the ability to decline to respond to multiple emails and phone calls once that decision has been examined and decided upon in a board meeting. So, this does allow you to then say to the owner, yes, we've received your complaint, we've examined it, we've made our decision, and we have minutes to show that this occurred. So if they do continue to send repeated emails about the same thing, at least you have on record that it was under review and decided upon. And as a reminder, oh yeah,
sorry,
go
can
ahead.
I jump in for a sec?
Yeah.
Another thing to keep in mind is that if the owner keeps sending you an email before the board meeting, saying that we want to talk about it at this next board meeting, or we want a response right now, or whatever it may be, starting January 1st of 2026, you basically can't do that. So as we know, the meeting statutes are changing. The board, as Tima said, has to discuss this as a board at a board meeting, which requires 14 days notice to owners if it's a special meeting or it's not part of a published schedule. So if you have to call a board meeting to talk about this, you can acknowledge the owner's email and then respond that it will be the next board meeting and that the board will not have an answer in less than 15 days. Because it's not, except for an emergency, which allows like immediate or 3 days notice, which most things are not because it has to be declared by the government as an emergency. Or it's something that was reasonably unforeseeable, like a demand letter from an attorney that allows for 7 days. For the most part, it's going to be 14 days. The board's not going to have a response until after the board meeting. And it's okay to start telling people that. Like, we're going to start getting demand letters from attorneys, and we're going to say, the statute changed. There's no way you're going to get a response by the end of the week like you're demanding. That's the law. And so just if you add it to the agenda, great. But just know that when you acknowledge it, you can also say, stop emailing me because it's not going to get a faster response. We have to wait till the next board meeting. Sorry, I didn't mean to interrupt.
Yeah, no, I think that's a great point. I think, acknowledging, as I said, Psych 101, acknowledge the complaint, say, hey, we got it, but also set expectations right away when you send that response. That's Katie's saying. The minimum that we can get you a response is 15 days. So that way, at least you've established that acknowledgement, and you've established expectations as to response, and any type of poor decision that may be made in this relating to this complaint, what have you, that is clearly not an emergency. As we're answering this question, we're assuming it's not an emergency. Most things aren't. So, um, actually, I think that covers it, Katie.
So
Unless
I
you have
am going
anything
to
else to
add
add.
something else. So we have gotten wind of proposed legislation that will basically require, it hasn't been proposed yet, we don't know the official language, but there is a inkling that there will be some sort of proposed legislation that would require the board to provide a substantive response within a certain amount of time. We don't know what that amount of time is. We don't know the actual language, but that is something that there are rumblings in Olympia about doing. So pay attention to the Monday minute from the LAC. If you're concerned about the notice requirements, substantive decisions being made over email, or the ministerial acts, which we'll talk about later, if you're concerned about requiring this response within a certain amount of time, keep an eye out for the Monday minute, because you can contact your legislature if you're very passionate about this and maybe testify. We'll provide more updates if this is actually a thing. The session starts in January, so we won't know much until then. You will need to re-sign up for the Monday Morning Minute, even if you were part of it last year. They wipe everything for each session, but we'll put the link and we'll update you. It's just, this is something that may come down the pike, so it's important to be aware of. I think that was all I had to say on that. And so with that, there is one follow-up question that I'm going to bring up now, kind of related to this, which is, what if our bylaws say you modify the agenda 72 hours before meetings are scheduled for the entire year? So we can't comment on what your bylaws say or what the proper procedure would be without reading them. I will say the statute for meetings allows either you to schedule board meetings with 14 days notice, and you send out the agenda for that meeting with the 14 days notice. The statute also allows for basically a single notice of a published schedule of meetings, time, location, etc. included. Board meets first Tuesday of every month at 6 p.m. Here's the Zoom link. That is where we say that the board can have basically a standing agenda. Obviously, you're not going to know what you're talking about on the agenda when you send out the notice in January for your November meeting. So at that point, you send out the standing agenda, and we think updating it once you know more about what will go on the agenda within a reasonable amount of time, and sending basically an updated agenda out, is reasonable. So we have some associations where it's not in their bylaws, but they update it 3 days before. We have some that are doing 7 days. The safest option would be to do it with 14 days, because that's the minimum amount required if you don't do the published schedule to send out the agenda. So, I mean, I don't have my thumb that on the pulse in Olympia, but I don't think that they're going to clarify when you need to update the agenda in this next round of legislative action. So for the most part, just act reasonably and try to give owners as much notice as you can, because the more owners know, the less they'll complain, in theory. Can't fix everyone. There was another question, is, can the meeting schedule notice be for the whole year or only a certain period of time? It is the whole year. So basically, you do have to send a new schedule every year. But if it's the first Tuesday of the year, that's an easy notice to send. in part why I wouldn't say, oh, board meetings are for the next 2 years at X time is you may have a new board, things may change, the board may want to change that schedule. So you can certainly do a year. I wouldn't do more than a year. All right. Now we're going to talk about Google Groups and Facebook groups, which I'm sure everyone's favorite thing. Um, so this question is, we are seeking guidance on legal and governance considerations about owner-wide communication channels. Our association currently has a Google group that allows any owner to send messages to the entire membership. It was originally created for safety notifications and general neighbor communication, but it has only been used for broader commentary on board decisions. Our governing documents do not authorize or require any owner to all owner broadcast platform, and our rules and regulations actually restrict owner use of online forums and allow the board to suspend or discontinue platforms that are misused. From a best practice and liability standpoint, is it advisable for a board to maintain such an open broadcast channel? And if the board determines it is advisable for the board to if determines that the current format is no longer serving its intended purpose, what are the appropriate and lawful processes for modifying or discontinuing it? So the short answer is no, it's not advisable to have an open broadcast channel. As the question alludes, it does quickly devolve into a complain fest. So if the platform's being used to discuss board decisions or potential board decisions, this is going to violate the open meeting requirement that applies January 1st. So if the board's using it to talk, if it's just owners complaining about the board's decision, that's obviously not going to violate any meeting requirement, but it does not make people want to serve on the board if their decisions are constantly being scrutinized over the internet. And I will say it's a lot easier for people to be mean through a screen than like at a board meeting or to someone's face. So it doesn't create a community feel necessarily. If the board is using it to send notices, that's going to violate the notice statute because I would have a really hard time arguing that an owner using a Google group is them consenting to receive notice through that Google group. So in terms of safety or general communication for things that require formal notice, this would not be effective. So you could try and restrict the use to only the safety and neighborhood communication as intended, but it's going to be impossible to enforce. So, I mean, I had a coyote in my street the other day. There may be a reason of like, hey, there's a coyote. Everyone watch your pets. And it may have a good function there. It's just how do you allow someone to say that and not then restrict someone else's ability to say, I think the board smells or something like that. Because the board can't control what people say on these forums. The board also can't control if owners create their own neighborhood group or Facebook chat group. So, but there is a difference between one run by the board and one where owners just create on their own. The board can control one if it's set up by the association and can sometimes prevent a group from setting it up pretending to be the association. So you couldn't create, like owners couldn't create, we are sample association, period. But they could say, like, concerned owners of sample association, and that would probably be fine because they're not holding themselves out to be the association. And again, those groups can be useful to some communities, but if it's being abused and it's created by the board can take it down. And there's no rules or laws about what they have to do. So if this is not an effective thing for your community and it is run by the board can just take it down at any time. In theory, you don't even really have to tell owners that you're doing it. They could just deactivate it. If you want, you could say, hey, we'll be disbanding this starting tomorrow. But again, the board controls it. There's no right to this Google group for the owners or this Facebook group, so it can just be taken down. So RCW 6490-445, which again applies to all communities, January 1st, 2026. It's the meeting changes. I'm going to say it till I'm blue in the face. This is intended to provide all owners the ability to understand what the board is doing. And it gives all owners an opportunity to participate and opine on board decisions limited to 90 seconds per person for a total of 15 minutes. That's what the statute requires. The association does not need to provide more ways for owners to complain to their neighbors about board decisions. They have what the statute provides, and that's that. Tima, do you want to add anything? I know I kind of
No, I think
went on.
yeah. No, I think that answers the question, at least the way it was framed. And of course, if there's something more specific going on in these forums that, you'd want to contact your association attorney and deal and manage it. But clearly if board decisions are being discussed and these types of complaints, as we already discussed in the previous question, owners submitting complaints over it's essentially the same thing as an owner submitting a complaint over email. It needs to be acknowledged. It creates a lot of administrative burden on the board and the managers if these forums are being used that way. So clearly it would need to be taken down. And in general, I don't think it's going to be a very effective way of communicating.
I'd also add if you have a communication and anti-harassment policy that tells owners how to communicate with the board or the manager and how decisions will be made, if an owner brings a complaint through this forum that is not what is provided for as the official form of communication with the board, meaning it wasn't sent to the manager, it wasn't sent to a designated board email or whatever, I would argue that the board doesn't even need to respond to it.
Yeah.
Unless it is the official way of communicating with the board, which we would not recommend. So I will let you talk about budgets.
Okay. The second, I guess we're on our fourth question here. If notice of the budget ratification meeting doesn't include the location or a specific start time, would collection of the increased dues still be enforceable? Our notice, the further detail is our notice said that ratification would be considered after the board meeting, and it gave a start time for the board meeting. Is the location really required if meetings are always held in the same place? So the short answer to the question is this depends. Without seeing the notice itself, reading it, and knowing all of the circumstances, I can't really give you a certain answer here, obviously. But I can tell you that in general, most owners, these issues don't come up unless you have a collection issue. So most owners are just going to not pay attention, frankly, to the budget ratification meeting, maybe not even attend. Most don't, and go ahead and pay the increased fee and not ask any questions. These issues come up when an owner becomes delinquent on their account. They're referred to us or another collection firm or agency. And then we need to go through, as many of you have worked with me or Lisa or Valerie, one of the first things we do is we look at the budget and we have to determine if it's Kiowa compliant. So there's two statutes that are relevant here. The budget statute itself, 649525, doesn't actually require time, date, and place. It only requires that you set a date for the meeting. However, the notice portion of the statute states that an association must provide notice to unit owners of the time, date, and place of each annual or special association meeting, and then we have a 14 to 15-day notice requirement. So the answer is that if you don't have the time and date and place of the meeting, most likely it could be an issue when it comes to collecting upon that increased assessment amount. And we would conservatively recommend that you re-ratify the budget and have in your notice the very specific time, date, and place of the meeting. And in fact, not only do you need the time, date, and place, if you are holding the meeting over Zoom or another electronic function, you do need to also include a call-in number for owners who don't have access to the internet. I would further add that when we, at least our law firm, when we look at budgets and determine budget packets and determine what Kiowa compliance, we look at the budget as a whole. It's determined on a case by case basis. Yes, there are very specific requirements if certain things are not there, if there are disclosures that are not required, disclosures that aren't there, or they're only partially there, those are going to be an issue when it comes to collections. But if the only thing missing, for example, is the call-in number, but you have the time and date and place of the meeting, not always are we going to say that it's not Kiowa compliant as long as everything else is met. So again, we look at these as a whole. It's not always a yes or no answer. But this specific question that you're asking, of course, I think our recommendation would be if you came to us and we would say, listen, if you didn't have a collection issue, it probably wouldn't come up. But once you have a file referred to us for collections, we're going to be looking at that budget packet in a very different way and we're going to be looking at it under a very strict compliance standard. Let's see. Yep, I think that's all. Katie, do you have any thoughts on that you wanted to add?
I think maybe just a clarification is you have to provide you don't have to provide a call-in phone number if you are having a only physical meeting. Meaning if you're meeting at the library or your cabana or whatever, there is no requirement to provide a call-in option. The call-in option is only if you are doing any sort of virtual meeting. So, for example, if you don't have the place and you don't have a call-in option, that's bad. I think it's for collections matters. Because also even if you've been having it at the same place every year, what if you have someone new who moved in and they don't know what that place is? So I would add the place. I would definitely add the phone number if you have a call-in option or Zoom. But for the most part, again, you don't need a call-in option if you're doing it in person. But least risky option is to tell people where to go.
Agreed.
All right. So next question is, we use a consent agenda to report votes by email between meetings, still allowed for non-Ukiah communities until January 1st, 2026. That the presentation seems cumbersome, and we'd like to know if there is a better way to do it. So the question did contain a consent agenda, and we're not going to evaluate it in this forum. But generally, a consent agenda would contain multiple specific motions with whatever detail is required. We prefer that the motions be spelled out in the consent agenda, like approving the meeting minutes or approving a contract for gutter cleaning. Don't just say approving contract, that's not helpful. But no further detail may be required. Remember, the minutes are just supposed to reflect the actual action taken by the board at a meeting. It's not supposed to be a transcript or anything like that. We recommend any individual item on the consent agenda can be pulled for discussion and a separate vote by any board member, meaning if someone does not just want to agree to the consent part, pull it out, have the discussion, have the board vote. You can research online for different ways to use consent agendas, or you can ask your attorney to review yours for specific use because you still want to comply with RCW 6490-445. So there's kind of a follow-up question, which we would have talked about anyway, because consent agendas are going to be pretty difficult for certain things starting January 1st, 2026, because fewer things will be able to be done exclusively over email. So the part two to their question was, after January 1st, 2026, we are aware that only ministerial items can be voted on by email. We have made it our practice to prepare and vote on meeting minutes by email as soon as after each meeting for early distribution to owners, but approving minutes most likely falls outside the category of ministerial items. Do we have to discontinue our practice of distributing minutes early, or is there an alternative? So the answer is maybe, because we don't know how courts are going to interpret this ministerial act for a while. The statute does not provide a definition of ministerial, though it would have been nice. And an argument could be made that approving meeting minutes is actually a ministerial act. So it may depend on whether or not there are edits to the minutes that are requested. If a set of minutes is sent out and all board members approve without edits, we think that that would be ministerial. But if there's any discussion about what the language should be, it would no longer be ministerial. Remember, for the vote on ministerial action to be valid, or the vote on a ministerial item to be valid, you need 100% participation from the board and 100% agreement of the board over email. So if you have one person, even if it's a ministerial act, who doesn't check their email, or it goes to spam, or they're out of the country and they don't vote, that's not a valid vote under the statute. So you'd need to do it at a board meeting anyway, but that's just important to keep in mind. Since the statute has not gone into effect yet for non-Ukiah communities, there is no case law to interpret it. So like I said, we still won't know January 1st, 2026 for everybody. We're going to need a court to determine what a ministerial act is. And so if you want to be the least risky or the most risk averse, it's best to just approve the minutes at the next board meeting. That would be the lowest risk option. So again, the statute has an open meeting requirement. We've talked about the 15-minute, 90 seconds per owners earlier. The statute limits the kind of decisions that can be made outside of a meeting, specifically to undertaking a ministerial action, which again is undefined. Some declarations, if you're doing a restatement, or the bylaws will try to add a definition. So if you're looking at redoing your documents, consider adding a definition for ministerial action. Other decisions outside of board meetings are taking actions that the owner must ratify before they become effective, and taking actions to implement votes already made at a meeting. So if the board already voted to sign the gutter contract and it's something small, like, I don't know, adding the date, that can be done outside a meeting because the board already voted to proceed with that. But again, decisions must be unanimous with every board member voting. So some examples of things that we think may or may not be ministerial are: a motion was made and passed to approve the removal of 2 hazard trees in a common area for a cost not to exceed $2,500. Then the manager of the board receives a bid from a contractor for $2,200. It meets everything that was voted at the board meeting. The board could approve entering into the contract by email with unanimous consent because it would implement a vote already taken at a meeting. Another example might be the board decides via email to hold a budget ratification on December 20th. The board could approve that action because the owners will ratify the budget before it becomes effective. Just agreeing on a date for a meeting might be considered ministerial. This might extend to the board adopting the final budget by unanimous consent because, again, it will be ratified to the owners before it becomes effective. A more complicated example is if you want to make changes to a policy. So, for example, say you want to change unit owner to owner in all of your policies so they're uniform. We think that that is not a substantive change, and that could be ministerial and done over email, meaning you wouldn't need to have a whole meeting. Now, if you want to change your fine amount or your late fee amount, that is more substantive and we think would fall outside of the ministerial act that would be permitted. So also keep in mind, if you want to try and make your lives easier, we think more detailed policies could make more things ministerial. So standardizing more procedures, like authorizing payment of routine bills, which your management company or the management company is probably already doing, those could be made ministerial, meaning a policy that says manager pays insurance every month, or the electric bill, whatever it may be. That can help make things ministerial. So basically it would be helpful probably to have a policy, even though the management contract says the manager takes care of monthly bills or whatever, a policy for the board that says the manager is authorized to make monthly reoccurring bills or payments on monthly reoccurring bills would be appropriate to kind of help streamline things. Again, ministerial is not defined though. So our examples, we don't know what a court would actually say. We can just support reasonable arguments that these things can be done outside a meeting, and that they're ministerial. If you have specific questions about whether or not a certain board action would or would not be considered ministerial or should be done in an open board meeting, then contact your association attorney. There is a question of taking down the board Facebook group be ministerial. I would say that should probably be a discussion at the board meeting because the board needs to have a giant conversation about whether or not there's any benefit of keeping it. And for the most part, if you don't want to ask your attorney if something's ministerial, if you have to think, is this ministerial or not, the least risky option would be talk about it at a meeting and
Right.
don't risk it. Anything
When
you
in
want to add,
doubt,
Tiva?
yeah, I was just saying, when in doubt and you can't get an answer from your attorney or whatever, and you have the meeting in 3 hours, and I just bring it up at a meeting. There's no harm in doing it that way. It's the safest option when in doubt. Although I do support Katie's recommendation that you have a defined policy on what are ministerial acts to be performed by either a designated board member or the manager or what have you. I think that makes things transparent for everyone and far more enforceable, or at least more likely to be enforceable in the event of a appearing in front of a judge and arguing whether or not an act was ministerial. Our last question that we have for today is, what, did you have anything else to add? Sorry. Okay.
Oh,
I was wondering if you know if having a person on the board who owns a roofing slash gutter company would be a conflict of interest if the community uses their services. So I will answer this question. I think specifically whether it's a roofing gutter company, a window washer, I think this question could be answered generally to pertain to any type of service that a board member owns. And the question is about conflict of interest. So I think I would first distinguish the difference between an actual conflict of interest and a perceived conflict of interest, because probably most likely in the scenario you're describing, assuming that that I would say there's not likely to be an actual conflict of interest as long as the decision to hire the roofing gutter company, window washer, whatever, is made in compliance with the open meeting requirements effective January 1st. But I'd say go ahead and start following those rules now. And there's been an open comment period, all the things that you know that we've discussed about open meeting requirements, and is made in, and the decision is made in the exercise of ordinary and reasonable care with regard to the association's, the best interests of the association. So that being said, now this doesn't mean that an owner might not say, well, this is a board member's company and this seems like a conflict of interest. Well, that's sort of a different scenario than an actual conflict of interest. So whether or not, and depending on the number of owners that object to it, or it may in fact be not worth it. If it's going to be a major conflict among owners, and it just depends on the scenario, we would recommend that the board member recuse themselves from that decision. Obviously, when that's taking place, that certainly would help with the perception of a conflict of interest. And I guess another consideration, sort of bird's eye view consideration, would be, well, in some communities, for example, if you're living in downtown Seattle, you may have a number of options as far as contractors for your particular issue. However, there are exceptions where we have communities in more rural areas, in places where it's quite difficult to actually find contractors, or they have a very specific need, a certain type of contractor that's very experienced in placing widgets in corners. I don't know, but whatever that is, and there's in fact only one company in the 60-mile, 50, 100-mile radius that actually does this work and that happens to be owned by a board member, that would certainly be an exception to any type of perceived conflict of interest, and certainly actual conflict of interest, as long as all of the other recommendations that we've made about actually making this hiring decision are followed. So, you know, again, I'd say generally speaking, it's probably not, as long as you go through the proper channels, and the decision is made in an open forum as is required by the statute. Katie, did you have anything you wanted to add?
No, I think you covered it. And so with that, we'll go to the questions from the chat. There are a few that probably are looking for more of a specific answer than we can give today. So I will read the first one and then we'll tell you which ones you should contact your association attorney about. The first one does happen to be one of those, which is what happens when a person who is requesting a large amount of documents is not willing to pay for the labor that it takes. So you should consult your association attorney about this, because there are specifics about basically a recommendation on how to proceed with this requesting owner. But generally, the statute lists what the association must maintain, what can be redacted, and what needs to be provided. It does allow for reasonable charges for basically the manager's time together. That's a big overview. Sometimes owners don't want to pay that. The question is, do the records still need to be provided? Without knowing what the records are, we can't answer that because, for example, some records, like the list of all the owners' names and addresses, has to be provided once a year for free. And so that would, what happens if they're requesting that and they don't want to pay for it? You still have to provide it. And so this is getting a little too specific, but sometimes if an owner is not willing to pay, you can talk to them beforehand and get them to narrow their scope. Otherwise, you could assess it. Again, it has to be reasonable, and this is a little too specific. Looking for a specific plan of action, there's no black and white answer. So the next question is, this has been touched on, but can't find anything specific. Quorum is reached and several owners want to reject the budget. Is it 51% rejected by owners in attendance or total ownership? If the latter, how do you now create a ballot for those not in attendance during the actual voting process? This seems to be impractical. Tima, do you want me to do this, or do you want to start?
Well, I'll jump in and then maybe you want to add to that. I would start off by saying that at the ratification of meeting, if a majority of the owners in the community do not reject the budget, it's ratified. So the budget ratification meeting doesn't actually require a quorum to be present because the budget is ratified unless the majority rejects it. However, if the proposed budget is rejected or proper notice isn't provided, then that would be more of the barrier here. But essentially, if the quorum is not present at the meeting, budget is ratified. If you have a quorum, but no motion to reject the budget, then the budget is ratified. If there's a motion to reject the budget, but a majority of the total voting power in the association does not vote to reject the budget is ratified. So this is all assuming that there's not something more specific in your governing documents about budget ratification specifically. Did you want to add to that, Katie?
A few things. One, the statute says that you need 51% of the total ownership to reject the budget unless a larger number is required to reject. So we have some associations that say 90% of the owners are required to reject the budget. That would meet the statute. What wouldn't is anything less than that, meaning if it's like 49%. And also remember, like Tima said, the budget is accepted unless it is rejected. So if no one shows up, there's no quorum, and the budget is ratified. So the second question of how do you create a ballot for those not in attendance during the actual voting process? You don't.
You don't need to.
You don't have to. You don't have to do absentee. If they don't show up, their non-vote is essentially a vote to ratify. Again, you don't need affirmative approval. You just, if they're going to reject it, there needs to be an affirmative rejection. And so if you don't want to make ballots because you can't make a ballot for something that doesn't exist, like someone showing up, just don't, because yes, it would be impractical.
I want to jump in with one other earlier budget related question here about it was about the reserve study. The question is, if the board does not update the professional reserve study, is it okay for the budget package to state that the association has a reserve study that meets the requirements of 64 of WCA Iowa? So I guess so. I need. Did you want to
I
answer that?
think that question might be too specific without
Yeah.
looking at specific language.
Yeah, I'd have to know a little more about that. I'd say, but to answer it's you are required to disclose whether or not you have a reserve study. I'll answer it more generally and if you have a reserve study that whether it meets or does not meet the requirements, and if it does not meet the requirements, you have to specify exactly, the deficiency per unit or per watt. I believe, and Katie, you can correct me here, if you have a reserve study, I think they're required, the recommendation is that it's updated at least every 3 years, not every year necessarily. So I don't
So
know.
the reserve study needs to be updated every year. You only need to do a visual inspection every
Every
three
three
years.
years. Okay.
But the person who submitted this question, if you want to submit it for next week, we can provide more statutory reference for what needs to be in a reserve study and what needs to be done every year. But
Yeah.
at least it needs to be updated every year. Again, visual inspection only 3 years. You are right about the deficiency per unit or surplus. Some people
Correct.
have a surplus, few, mostly it's deficiencies.
Yeah.
Um, okay.
Yep.
So Tima, I think this one may go to you as well. It may be too specific. If an audit is performed and a homeowner has not been charged their assessments, is it okay to backdate those charges?
Well, again, that's going to be, I can't answer that without, we have to do a full review of what exactly you're talking about. And, for example, how far back we're looking, there's statute of limitations issues in certain situations. So I don't know if I can answer that beyond saying, I recommend that you send that documentation to your association attorney, have them do an intake and look at the owner's history as a whole, and then determine what can and cannot be added to the ledger. Sometimes yes, sometimes no. So it simply depends on a lot of things.
Well, I have another it depends answer. So, does a board have a requirement to act when blackberry bushes are growing onto an owner's yard from an NGPA? So, just like last one, it depends. Um, we won't know without looking at specific governing documents, the type of community, what obligations the association has. The obligations in a natural growth protection area, which is an NGPA, are different and limited by usually your local municipality of what can be done within the NGPA. Sometimes there are rules that restrict basically if the thing like the tree is in the NGPA, I know this is actually about blackberry bushes, but if it's in the NGPA, sometimes you are more limited, even if it extends outside. But then other times you can do whatever you want to things on your property, like trimming back blackberry bushes. So it will really depend. It also depends on how far they're encroaching. There is a difference between an owner doing something and the association doing something, and also if the association has any authority to act. Generally, for those of you who don't know, things in an NGPA, usually the language is left permanently undisturbed unless XYZ. So we can't answer this. because we don't know the if XYZ, meaning dead, dying, diseased, whatever, or where the NGPA is and whatnot. So contact your association attorney if you're concerned. Some municipalities, just as a heads up, care more about what you do in your NGPA than others. And some of them will fine you hefty fines if you remove a tree from an NGPA. So do be careful if you know you have one and depending on what you want to do. Blackberry bushes crossing over a property line, probably a little different than removing well, there aren't oak trees here, but say a giant oak tree from an NGPA. All right, hold on. Another question is, does an HOA bank account need to be FDIC insured? We can't answer that question without knowing your association and your statute. There are some statutes that require all bank accounts be federally insured. That's not necessarily copied in all of them. So start by looking at your governing documents and your statute. So that's that. Would each item be motioned in a consent agenda or the whole portion? It's my understanding that you make a motion to consent to the whole agenda, and then that motion's approved, which is why we mentioned if a board member wants to pull something out of the consent agenda to talk about specifically, that's why you would do that. If a Ukiah condo offered a 9-day notice that could void the budget if there is a quorum, then is there nothing you can do for an annual meeting? So I think this is too specific. The statute does not offer a way to void the budget that way. In theory, owners could call a vote to void the budget, but I think this question is too specific. And but also if the question is, if you only sent 9 days notice, could the budget be voided? And I will say, if you only sent 9 days notice, the statute very clearly says that if the notice of the budget is not compliant, then the prior budget stands. So that's a different question. So I'm not quite sure what you're asking, but I'm also not sure that we can answer it in this forum. Tima, this next one is a motion required to reject the budget?
No.
Right. Because also, if no one shows up, there's no one to make a motion. The budget's ratified.
Well, we just talked about it. So no, I didn't mean it in a short, like in an exasperated way. Just answering. There is another question here. Does the portion of the statute which states not less than 14, no more than 50 days in advance of a meeting, so the notice requirement, does this only apply to notice of special meetings? Again, no. An association must provide, I'll just read it, must provide notice to unit owners of the time, date, and place of each annual and special unit owners meeting, not less than 14 days and not more than 50 days before the meeting date.
And also remember, starting January 1st, 2026, if you don't have standing board agendas or standing board meetings, you have to provide 14 days notice of board meetings as well to all owners.
Right.
So
all meetings, any meetings,
yes,
just
any meeting
give
with some
days.
exceptions, but talk to your
emergency
attorney for those. With that, there's some questions we're not going to get to. Feel free to send them to info@condolaw.net. We will be meeting next week, just not the 24th or the 31st. So submit your questions by 4 p.m. on next Monday. And if we didn't get to any of them, feel free to send them there, and we will do our best to answer them. Thank you all for joining us today, and see you next week.
Thank you.